To understand dual agency, we must first explain single agency. What is single agency? Single agency is when one brokerage represents a buyer or seller on a transaction, but not both. Most real estate transactions consist of two single agencies. What is dual agency? In contrast, dual agency is when one brokerage represents both the buyer and the seller. Dual agency occurs in the following circumstances: when the same salesperson represents both the buyer and the seller, when two different salespersons from the same brokerage represent the buyer and seller on the same transaction. This is still considered dual agency because one firm represents both the buyer and seller, even though each party is serviced by a different subagent. Next, when a salesperson purchases their own listing or the brokerage's listing. And finally, dual agency occurs when a salesperson represents two different buyers who make offers on the same property. Is dual agency legal? Dual agency is legal in Hawaii. Nonetheless, it is up to the brokerage to decide on any guidelines or restrictions regarding dual agency. A popular dual agency option is called designated agency, in which a broker designates one salesperson to represent the buyer and another to represent the seller. What are the rules for dual agency? Dual agency is allowed only if both parties, buyer and seller, give informed and written consent. In Hawaii, this is achieved when both parties sign the dual agency disclosure and consent addendum. When do agency relationships need to be disclosed? Agency relationships need to be disclosed at these specific times. When the property is listed, the agreement must be in writing, signed, and dated by seller and brokerage firm. Prior to preparing any contract, this may be in writing or orally. Prior to presenting the contract, this may be in writing or orally. Confirmed in writing on the sales contract. Why do agency relationships need to be disclosed? An agency relationship should be disclosed because agency may be implied by the actions of a licensee. If a licensee behaves as an agent would with a buyer or seller, they are implying agency. Why would implied agency be a bad thing? If a dispute arises because a consumer believes they had a fiduciary relationship with a licensee and the licensee did not act in their best interest, this could result in legal trouble. For example, let's say a licensee represents a buyer, but the seller is unrepresented, in other words, has no agent. In this case, the buyer is considered the agent's client and the seller is considered a customer. The agent has a fiduciary relationship with the client, but not the customer. Implying agency with a customer could result in a lawsuit if something goes wrong in the transaction. How do agency relationships end? Termination of an agency relationship occurs if and when the contract is fulfilled. For example, the home sells. The contract expires. For example, the home doesn't sell before the listing period ends. Both parties mutually agree to end their agreement, or the contract can't be fulfilled. This may happen if the property is destroyed or legally condemned, the principal or agent dies, or is incapacitated. One or both parties breach the contract, or the principal declares bankruptcy. What is power of attorney? Power of attorney, POA, is a written instrument that authorizes one person to act on another's behalf. Power of attorney creates an agency relationship that must be in writing. What is the agent called in this relationship? In the context of power of attorney, the agent of the principal is called an attorney in fact. The attorney in fact has power of attorney from the principal. To avoid unnecessary liability, a real estate agent should not act as attorney in fact for a client. What are the types of power of attorney? General power of attorney. Under general POA, the attorney in fact is a universal agent authorized to act on behalf of the principal in any capacity. An attorney in fact with general POA may have the power to enter into contracts on behalf of the principal, manage their bank accounts, mortgage their property, or admit the principal into a nursing home or medical facility. Special power of attorney. Under special POA, the attorney in fact is a special agent. Special POA gives the authority to act on specific tasks. It can be limited for a certain amount of time and can be drafted for virtually any purpose. Durable power of attorney. Durable POA lasts even upon the incapacity of principal. What are the rules for POA in real estate transactions? Recording rules: the POA must be recorded if the property is registered in land court. If registered in regular system, recording a POA is not required, but still advisable. If an escrow company is involved, the POA will be recorded regardless of which system is used. Real estate license rules. Under HRS 467, an attorney, in fact, does not need to be licensed in order to sell real estate on behalf of the principal, unless the POA is being used to evade licensing laws. This is not a rule, but a real estate agent should not solicit or accept power of attorney from a client, as it could potentially bring about a conflict of interest. How does power of attorney end? Power of attorney is terminated if any of the following occurs: the principal dies, becomes disabled, or incapacitated. The principal revokes the POA. If the purpose for the POA has been completed, if the POA expires, or if the reason for POA no longer exists. How do real estate agents get paid? Payment for a broker's services is called a commission. Real estate agent commissions are paid by the sellers at closing from the proceeds of the sale. The commission is typically a percentage of the sales price of the home, although it can sometimes be a flat fee or a combination of a flat fee plus a percentage. First, the listing broker receives a commission from the seller at closing of the sale. This commission amount was agreed upon in the listing agreement between the seller and the listing broker. Next, the listing broker shares the commission with the cooperating broker or buyer's agent. This shared amount was agreed upon in the cooperating brokerage agreement between the two brokers. Finally, the listing broker and cooperating broker pay the agents who represented their clients. The listing broker pays the salesperson who assisted the seller, and the cooperating broker pays their salesperson who assisted the buyer. The final payment amounts are based on the commission split agreement each licensee has with their broker. As a side note, experienced agents tend to have higher commission splits than brand new agents, since new agents require lots of training and oversight at the broker's expense. When does an agent earn a commission? In other words, when is an agent entitled to a commission? This is not the same as asking, when does an agent get paid? An agent is entitled to commission if they produce a ready, willing, and able buyer, but the deal doesn't go through because the owner stops the sale. Yes, in this case, a broker is still entitled to a commission if the seller simply changes their mind and/or decides not to sign, refuses or neglects to correct title issues, commits fraud, fails to hand over the property within reasonable time, changes their mind and requires new terms not included in the listing contract, or colludes with the buyer to cancel the contract, cut the broker out, and sell to each other directly. If any of these situations occur, the agent has earned the commission, even if they haven't received a commission. This agent has the legal right to pursue damages. What percentage should real estate commission be? There are no set prices for real estate commissions. In fact, there is a law against fixing real estate commission fees. Realtors are not allowed to collude to determine a set price for their commissions. Price fixing is illegal under the Sherman Antitrust Act. What other laws exist regarding agent commissions? A licensee's commission must come from the agent's brokerage firm, not directly from client or customer. The purchase or sale of real estate owned by a licensee must be transacted through the licensee's brokerage firm. If a licensee is a property manager, he or she must be paid through the brokerage firm. A licensee may not split a commission with a non-licensee. If an agent is licensed in another state or country but not Hawaii, he or she can receive referral fee for a Hawaii transaction, as long as they don't come to Hawaii for the transaction. Transient vacation rental agents can split commissions with licensees.